All right, I think I will go ahead and call this meeting to order. I am Representative Forrest Bennett from the state of Oklahoma. I'll be chairing the meeting today. Due to realities in my state politically, I had to travel halfway across the country to chair a legislative committee, and I'm happy you're all here to bear witness. We need a motion to waive the quorum requirement and a second. Moved and seconded. Thank you. All in favor? All opposed? It appears the ayes have it. We will also need a motion to approve the November 18, 2022 committee meeting minutes and a second. So moved? Seconded? All in favor? All opposed? So moved. We will start today with a presentation on insurance issues surrounding the name, image, and likeness industry. This is an interesting issue and one that that can have a big impact on the student athletes in your state. If you are in, say, Georgia or Louisiana, where there aren't really any notable athletic programs, this may not be a big deal to you. But as an alum of the 2025 SEC champion OU Sooners, I am very interested in this topic. 2025, gang, okay? With us here today to discuss this is Pat Brown, the Director of Risk Management and Insurance at Edmunds Duncan. We will hold questions until after Pat is finished. Pat, please go ahead.
Okay. Can I use the little flipper there? Thanks. All right, well, guys, thanks for allowing me to come and speak today. I certainly appreciate the time. A little bit about myself. Again, my name is Pat Brown. I'm a financial advisor in Lawrence, Kansas with Edmunds Duncan Investment Advisors, and played football for the University of Kansas many, many years ago. There we go. Thanks, Vicki. Played football, enjoyed myself immensely there, and became very passionate about the sport as I played. And along the way, I ended up getting very passionate about financial literacy for student athletes. And the way that happened, if those of you that have played sports in college, you have a 5-year scholarship. And so in football, if you go and you play, you can actually stay in the summer and go to class and so forth. And so I did that year after year and then graduated in 4 years. The reason I bring that up is because it wasn't like that was the first time that happened, but in order to be eligible to play my last year, I had to take courses in order to play. And well, I thought I would work my MBA, but it turns out the MBA was really kicking my butt when I was trying to take courses and play football. So I started taking some stereotypical classes like basket weaving 101, softball throwing, and one class in particular I took was transition from college to the workplace, which essentially exposed me to things like everything from stocks to bonds. And I became very passionate at that point and really wanted to work with student athletes. So fast forward, year after year, I would talk with the university and see if there was an opportunity for me to speak with the athletes about financial matters. And each year, they told me, no, don't worry about it, no. And it wasn't until 2 years ago that Wayne Simeon, who was an All-American at KU, reached out to me and said, hey, would you like to come talk to the guys about financial empowerment and financial literacy? So basically, I throw up all the information I just kind of rambled to you guys about, and was able to talk to the guys about financial empowerment. I say that because the whole point of them getting me in front of their players was because of NIL. NIL was coming down the line. And so is trying to get these guys exposed to these financial matters sooner than later is the main gist of everything. And so I put this little PowerPoint together to try to kind of go a little bit through the kind of history of NIL and then kind of where we are and kind of what I think as far as insurance and how these kids are essentially a target moving forward. So let's see here if I can work. All right. So, guys, I put this picture on here because every time I talk to student athletes, I want them to see that I, in fact, did play and I was in their seat as well. And so I just put my little credentials, outside linebacker, and I even autographed it for Will. Will, I don't know if you see that. You see that at the bottom, Will? You see that? You don't even see that, do you? But I just want them to realize that I was in their seat at one point in time as well, and that I know what it's like to try to manage school and sports at the same time. I mentioned my platform, Financial Literacy for Student Athletes. Basically what I've been doing is talking to former student athletes, trying to get them to tell me basically some of the pitfalls, some of the successes, failures that they've had while they played the sports, with the hopes that current student athletes will be able to learn from some of the successes and failures. Okay, so what is NIL? As you guys have mentioned before, NIL is name, image, likeness. This allows student athletes to now get compensated off their name, image, and likeness, whereas before we weren't able to get compensated at all. So if there was a camp or something back when I played, quote, a Pat Brown camp, I wouldn't be able to get compensated back when I played. So now these kids are able to get compensated, which is a good thing, depending on who you talk to. Okay, so the history. And the reason I'm going fast, guys, I want to make sure that, I do this within the time, plus Katie's going to play later on today. So the history of NIL, like I said before 2021, we weren't able to get compensated. And you have examples like Reggie Bush, who was forced to basically give back his Heisman Trophy because his family was getting paid from the university boosters, and actually had a house out here in San Diego. But Ed O'Bannon was the one that really kind of brought forth things back in 2015. The sports games that you guys may be aware of, the Sega, Nintendos, and so forth, he saw the fact that we weren't able to get compensated, student athletes weren't able to get compensated off the name, image, and likeness. And so he's kind of the one that really brought this forward, moving it forward, and which the case did settle. I still haven't received a check, but the case has settled for $40 million, and a lot of players did receive checks and so forth. Again, when the rules changed, as I mentioned, July 1st was when the rules changed in 2021. And so moving forward, student athletes are allowed to obviously get compensated. Okay, who's eligible for NIL deals? Basically, anyone who plays college sports are now eligible, men, women, regardless if it's D1, D2, D3. Even high schools are now able to get compensated. Athletes are able to get compensated off NIL deals. Here are the ways to find NIL deals. So anything from social media to autographs to advertising campaigns, student athletes are able to start their own business, whether that's T-shirts, whether it's I've seen some guys in the state of Ohio have real estate companies, but they're able to get compensated because of their name. And I mentioned there at the bottom there about the quarterback Bryce Young, who's in the draft next month, but he was getting deals for roughly $1 million when he played. And again, I saw Subway, Cash App, and some other companies. I put on your marketplaces, so again, not knowing how much or how familiar you guys are, but Open Doors, Open Sponsorship, Mogul. These are companies that are basically marketplaces where an athlete can go, put his or her name, and companies can actually contact this website and look for the athlete. They can agree on a compensation, and then moving forward, whatever contract they may sign, they can get compensated that way. And then there's collectives. And then basically collective, I found this definition of a collective actually not too long ago, and I slipped it in here. I'm going to read it to you because I think it's funny. So a collective are basically a collection of fans and boosters who pull together money that can pay athletes to play for a given school as long as they're not officially paying them to play for a given school. So if you can let that kind of sink in, it's a group of boosters who basically pool money together. Now, they can't entice an athlete to come to that particular university, but when that athlete gets to said university, who's to say that they can't say, hey, if you advertise this cup, we'll give you, $500,000 just for advertising that cup. Now, you can't pay a player to play, but you can pay a player to advertise. It's, I think it's the best definition of collectives I've seen so far. But again, that's a long discussion. So where there's money involved, there's risk. And so, I noticed an article that I did some time ago where I basically poked holes in risks that I see kind of coming down the pipeline with regards to these student athletes and how they essentially are going to be treated kind of like celebrities. And a lot of celebrities, from time to time, may get sued for frivolous stuff, regardless of if they did X, Y, Z or not. And that's what I see with a lot of these student athletes, because a lot of the information that's put out there on the internet it talks about the money that these student athletes potentially make. So whether it's 300, 400, 500, there's student athletes that, regardless of what site you look at, are making upwards to $1 million to $2 million for name, image, likeness. And so who's to say that, there's someone that looks at them a certain way and tries to arrange some type of situation whereby they get hit by a car by this particular student athlete to try to basically, sue them for something frivolous moving forward. So I just see a lot of casualties with name, image, likeness I think are going to unfortunately come down the road. These are some of the things with regards to insurance that student athletes looked at prior to NIL. And so I have on here permanent total disability. This was something that it only affected a certain portion of student athletes, and those athletes were athletes that potentially were going to go in the draft, either the first round, top 10, or what have you. And typically a university can maybe pay the premium. If these kids had financial resources, they would be able to pay the premium. But this is essentially saying if you got hurt and you could not play the game that you're playing, then this potential policy would pay out. So again, this is before NIL really came into play, came into focus. So again, who can buy this type of policy? Typically people in the first round, up to 3 years prior to their draft eligibility. But the devil's in the detail with these types of policies. Another type, which is actually an endorsement or a rider of a permanent disability policy, is loss of value insurance. So essentially, if the value of their draft went down a little bit, if they got hurt during the season and instead of going first round to go second or third, then this could potentially pay for the difference. So they could still get some type of money if their value suffered. And then critical injury, essentially, if they were it's kind of like an Aflac policy. If they were to hurt themselves, tear an ACL, they would essentially pay a certain amount. So what student athletes need to be concerned about after NIL? So after July 1st, 2021, some of the things I think are going to be, and this could go on and on, but financial fraud. Basically, the act of making a claim about a product or service that is not true of someone, and that someone cites that a student athlete meet activity as a reason for why they use that product or service. So the thing I think about with this, if you guys remember FTX, I don't know if you guys are familiar with cryptocurrency. So this cryptocurrency went under. It went bankrupt. And guess who they're coming after for that? Shaquille O'Neal, Steph Curry, Tom Brady. These guys are all listed as far as the lawsuit was concerned. They were just a spokesperson. They're basically they were an influencer, essentially. But yet they still got roped into this as well. Well, I see something similar, maybe not to that extreme, but I can certainly see something like that with regards to student athletes. If you have student athletes who have a huge following, whether it's social media or whatever platform that these kids are on, and they're either saying, okay, you should, buy a particular product and/or service, and that service is faulty, will these kids get roped in to something like this later on, moving down the road? I have down here libel, slander against a person or brand. A lot of times these kids are young. They may have a tendency to kind of go off at the mouth if for whatever reason they don't like a particular person. If they're an influencer, can someone in fact come back at these kids and say, hey, look, I'm offended, whatever, I feel a certain way that you said X, Y, Z about me on your social media platform. So, I see things that are just kind of coming down the pipeline with regards to that. Non-performance of a contract. These kids are signing contracts now. So if they don't get representation by, a qualified attorney, they may sign a contract that they don't really read. And so what happens when they don't do what they're required to do, whether that's post a particular something on a media site or post a number of things that they're supposed to do within a given time. What happens if that company or that organization comes back at them and says, you didn't do what you're supposed to do. You owe us X or whatever that might be. I have down here professional liability. That might be a far stretch, but, all professions have some type of shape, form, or fashion. Errors and omissions insurance. So again, from a liability standpoint, if these student athletes aren't doing what they're supposed to do with respect to whatever agreement that they get in with a particular organization. Same thing with commercial general liability. I look at all these student athletes as very similar to social media influencers. And I think that these policies or something like that should be something that these kids get or maybe at least exposed to when they get to school and they start doing these deals. And then again, I just have some examples of, potential things. Again, a kid going to a meeting and knocking over something, whether it's a computer or coughing a computer, is that kid going to be able to pay for that? If he's obviously has an NIL deal that's, paying X amount of dollars, then, certainly could. But if not, then, would a policy be a prudent thing for that particular student athlete? And then it's just obviously my contact information. But hopefully that was short and sweet. I didn't want to go down necessarily the rabbit hole with all this stuff. But I can if you guys want me to. But like I said, the KU game's coming on, so sure. Anyway, that's my question. That's it.
Thank you so much, Pat. Do we have questions? Senator Hackett, please.
Yeah, I just have a question. And Pat, I don't know if you could answer it or not. I'm chair of insurance in Ohio, and we're in charge of the workers' comp budget, and it's going to be coming over from the House in the next 2 to 3 weeks. And one of the things we see, there's an amendment in there that in pro sports, people qualify for, it's not permanent total, it's permanent partial disability, but they get paid for the contract. And I don't know if any of the other people here deal with it in other states with pro athletes. Anybody else wants to talk about it? If you can't, the pro sports teams, there's 2 of them. And there's a specialty law firm in Cleveland that will jump in and has a national reputation. And so the Browns and the Bengals and now the Blue Jackets, the hockey team in Columbus, they're facing this thing. And so they'd like us to do legislation that outlaws it. But the person does qualify for both under that scenario. But I understand they signed a contract. The contract is there. But do you know anything about that? Have you ever run across that in your travels? They do permanent partial, and then they get paid, and they even go back and play. And they still get permanent partial from workers' comp.
So no, I'm not as familiar. When you start talking about workers' comp, I'm not as familiar with that. I'm more, I guess, familiar with regards to college sports. There's obviously no workers' comp with regards to that. Well, not yet. I'll tell you what's going to happen with that. But there is the temporary policies that are floating around out there for disability. And again, I know the devil is in the details with those policies as far as who can actually benefit from those and file a claim. I don't know if that necessarily answers your question, but
well, I think the permanent partial is they can play with it,
right?
But it's still a disability. They do something. They
so
get
they're
hurt
able to file for both sides of that. Is what you're saying?
Yeah, and it does sound like it. Like he said, it does sound like it's double dipping.
Yeah, it does.
And another disability and all that other thing, which I've been in the business for a long time, you can't really double dip.
Yeah, you can't double dip. There was actually a kid from K-State who was playing basketball at the University of Miami. Some of you guys may know the story, but he passed that on the court, and he actually had a total disability policy. And so he either could file that claim, or if he fought back and continued to play, which he did, and he transferred to K-State, he was basically able to continue playing and not file the claim. It was like for $5 million. So he basically turned down $5 million to go play for K-State, which I wouldn't play for K-State. That's just.
Well, in this case, it's a pro. They actually do it. JP, did you know that?
So we dealt with a little bit of that in a couple of cases. If you look inside the contracts,
Thank you.
If you look inside the contracts of some of the major sports figures, most of their salary is not actually attributable to their athletic performance, that they have a separate executive sort of piece, which would be outside that. But obviously the total disability and partial disability rules are sort of separate, and I think you would have to figure that out, because that same rule, those same rules apply, I think, to people in general who have partial disabilities that may be able to continue to work, but just not work exactly in the same way or in the same field necessarily, but maybe similar and may have similar income. But I think that you'd need to be careful to sort of take a look as to whether or not it applies to other people as well outside the athletes, right? Outside major dollars.
Yeah, workers' comp says, well, it's so little we don't even want to mess with it.
Yeah.
The Bengals have showed me just this week, it's over 30 people in 1 year under that scenario. And then you add on the Browns and all the other. I'm just curious, is anybody, Matt, have you ever run across that, Matt Lehman, at all? I haven't either until It's appearing in the budget. It's going to come to me, and the pro sports don't want them to double dip. Just curious. Thank you.
Any other questions on this? If you have further questions, my paper here says to contact me or reach out to NCOIL staff, but let's be honest, talk to Will. Next on our agenda...
Wait, Mr. Chairman, if I may, I know Senator Hackett was verging on a filibuster there, but Pat, the thing he really wanted to ask you, and I'm shocked that he didn't, is he's desperate to know how can he get NIL money for when he played at Yale 5 decades ago. That's what he really wants to know.
I think they do have some old NIL money coming around, so maybe you and me both.
Thank you for your questions, Team Captain Senator Bob Hackett. Next on our agenda, and they were undefeated, by the way. You should ask him about that, or ask Will, maybe. Next on our agenda is a discussion on the potential development of an NCOIL Consumer Data Protection Model Act. We had an interesting general session on different types of data privacy laws at our last conference in New Orleans, and now we're going to start discussions surrounding whether or not NCOIL should develop its own Consumer Data Protection Model Act. We discussed this a little bit yesterday in our dialogue with regulators. Guiding this discussion today will be the Virginia Consumer Data Protection Act, which is on the website and the app and in your binders on page 249. The NAIC's development of their Consumer Protection Privacy Model Act will also be referenced. The cover page to that model appears in your binders on page 90, and you can view the model on the website and the app. Today we'll hear from our list of speakers and then determine how best to proceed in terms of developing an NCOIL Model Act. We'll hold questions until everyone is finished, and we will start with Andrew Barnhill of IQVIA. Andrew, please go ahead.
All right. Well, thanks so much, Forrest. I appreciate the invitation to kickstart the discussion about data privacy at the states as we start to think about, with NCOIL, potential models for the future. To really start this off, the perspective that I'm going to bring is one that helps us to balance the importance of consumer protections along with a framework that works particularly for healthcare companies and health insurers. And that's the direction that I'm going to take my comments today. So a little bit of background for those who might not have been in New Orleans when I gave a little bit of an intro into this. I lead public policy for IQVIA, which is the world's largest clinical research and health technology company. We conduct clinical trials in all 50 states and all around the world. And we have had a close eye on data privacy, particularly in regard to healthcare data, for as long as we've been in existence as an organization. And one of the things that we have found is that this discussion, this topic area, is coming to even greater focus at the states right now. Just a little bit more background on our company on the screen. I won't go through all of that, but gives you a sense of what we work with, which is a variety of types of healthcare data, both data that may be protected by HIPAA and other forms of clinical data that helps us in the delivery of care for patients all around the world. You might know us from some of our work during the pandemic. We conducted the clinical trials on 2 of the 4 approved vaccines. We also did a variety of surveillance work both here in the U.S. And in other countries to make sense of what was happening on the ground, particularly in partnership with state public health departments, including some of your states that are here represented today. One of the other recent examples of how healthcare data can really make a difference is an example that goes back to 2017 during Hurricane Maria that was hitting Puerto Rico as a really strong Category 4 hurricane, some of you might remember. We were contacted by HHS and the CDC to help try to come up with a list of the prescription medication usage by residents of Puerto Rico in assisting with some of the relief efforts. In using our data capabilities and extracts that we have, we were able to provide the list of all the top 200 prescription drugs in Puerto Rico and their utilization rates within 45 minutes of the request from the federal government. So that's just one example from one company, but I use that as we start thinking about the importance of healthcare data surrounding this conversation of data privacy, how it can be of service to the companies, to the patients, but also to our governments at the federal and state level as well. So how did we get here to discussing data privacy so much? You're seeing it in the news a lot now that you might not have been even just a couple of years ago. We have seen a failure to act by U.S. Congress as technology grows and advances, and as consumers become even more interested in who is sharing their data, who is selling their data, and what sort of rights that they have to protect that data, both in the healthcare space and in the consumer space as well. As a result, we've seen a number of states begin to act. Actually, California was among the earliest actors in privacy legislation and was first to hit the mark on it, and also inspired a number of states in the future. At present, we have 5 states that are pursuing comprehensive data bills this session, but there are others that are at various phases of the process. We saw some that were introduced in the last year's session that didn't pass, and you've seen other states that are beginning to consider legislation to date. There are also a number of bills out there that address particular types of data privacy. So you have some states that are interested in regulating data brokers, for instance, and have data broker registrations in place, such as what you find in California, Vermont, and now a proposal in Massachusetts. You have others that are focused on specific types of data itself, such as biometric data, healthcare data more broadly. And then you have this select group, which I've identified some of on the map here, that want to pursue a comprehensive data privacy standard for their states. Now, what we're beginning, of course, to see is that this creates a patchwork of policies out there, and other states have an incentive to act with the absence of federal legislation. Today, one of the models, or the model, that I think it's helpful for us to use as a launching point for discussion is Virginia's. Virginia passed the Consumer Data Protection Act in 2021. And this particular data privacy bill actually just went into effect January 1 of this year. This model is actually one that's being used by a number of states as they begin to draft their own bills. Florida, for instance, has borrowed a lot from Virginia. Colorado shared ideas with Virginia in their early stages. And there are several others who are recognizing the Virginia model as one that is workable for other states. This bill, now law, clearly defines whose personal data is covered. It clearly defines consumers as residents of the state who are acting in individual or household context. It also imposes no significant record-keeping requirements on insurers, healthcare entities, and other companies aside from documenting data protection assessments. So one of the things that we found with some of the proposals that have been bubbling up is the compliance and record-keeping requirements are difficult, particularly for smaller businesses. Well, Virginia makes sure that that is not particularly a challenge. It also clarifies that consumers are not those acting in commercial or employment context, and it separates the language between those two. There are some states that sort of merge the boundaries between when consumers are acting in their individual capacity or in a commercial or employment context. So what specifically does this bill protect? I've identified some of the key areas of protection here. One is the right to know, access, and confirm your personal data. Another, to correct inaccuracies in personal data. That was something that many consumers identified as something that they would like to see in their state's data privacy legislation. Another important provision, the right to opt out of the sale of personal data, which has certainly driven a lot of discussions in states and at the federal level on data privacy legislation. And then in addition to that, there are a number of other provisions that we see Virginia does really well. So why is this particular model good in the healthcare space, and why might it matter to health insurers? One, has a clear carve-out for protected health information under HIPAA. But in addition to that, it also identifies private information that occurs in the scope of clinical research or other forms of academic research as carved out of this particular bill. And so information that may have been de-identified in accordance with HIPAA or in accordance with requirements of clinical trials is given an exception for the purposes of this law itself. In addition to that, it's worth noting that it's helpful for some of those smaller healthcare businesses that we mentioned earlier by including what's considered a 30-day cure period, which allows companies to address some non-compliance. So if there is an identified issue with how their company is operating in the state relative to data privacy, they have the opportunity to correct it within a fixed window of time. So our argument is that we recognize the growth of interest surrounding data privacy legislation at the state level, particularly within the absence of a federal standard. And if we are going to pursue a model across a variety of states, the Virginia model that just passed a couple of years ago and went into effect 2 months ago is one that really carefully balances the interest of the consumers and the interest of companies, including healthcare insurers. So with that, I'll turn it over to JP, but hopefully that sets the stage for a discussion about this model here at NCOIL.
I'm JP Weisky. If Andrew's presentation is Smokey Robinson, I will function as the Temptations in this for this discussion. I think when you look at this issue from our standpoint, I think you are seeing a number of things come together from a data standpoint. You heard yesterday Commissioner Mulready talk about the NEIC and the fact that if this organization doesn't take action, that in the absence of that, you're going to see some significant issues that sort of attach in the states. And we've already started to see that. You've seen some crazy stuff in a number of states. Not to pick on Oregon, but Oregon, I believe, had a bill that would have required collection of dollars for anonymized data and to try to figure out how you would get money back to the consumer for anonymized services that were commercial in nature, which is obviously problematic. I don't even know how you do that. I would also note that Congress is unlikely, as we talked about, to take action given the split, given the issues there, that it's unlikely that there's going to be a consensus on movement and how you look at this. And I would also note that NCOIL uniquely, as we heard earlier today in discussion of the transparency model by Senator Lehman, that this is an organization where we can come to consensus and have a discussion, and we can push both sides of this discussion to come up with a middle ground that makes sense both for consumers as well as the industry. And I would also note that I think from an important standpoint, I think, and again to circle back to Ken Cooley, who was here earlier, he always said in his time as president of NCOIL that this is the place where you have the discussion and you go back to your states and you're the giants in your state and in your caucus about discussing these issues, right? And I think that's an important aspect of this as well. While we're wedded to a lot of the language in the Virginia model, we understand that there are pieces here that may have to be adjusted. There may be expansions that may have to happen in some protections and coverage of other areas. But I think this is going to be an important conversation for NCOIL going forward. So with that, I'll stop and turn it over to the rest.
Thank you, JP. Actually, we're going to have John Schnauz next, please.
Thank you. John Schnauz, National Association of Mutual Insurance Companies. Mr. Chairman, as a resident of Austin, Texas, I'm honor-bound to take issue with your prediction regarding the 2025 SEC Championship. It's weird to be arguing about this when we're not even in the same conference yet. Well, we are in the same conference, but we're going to be in a different same conference together. I'm also not a data privacy expert by any stretch of the imagination. If you watch The Simpsons, one of my favorite lines is Homer gets asked some real complicated question about something, and he says, I can answer that as long as you have no follow-up questions whatsoever. Which is not entirely true. I can try to answer some questions, but I guess the main reason I'm participating in this panel, or asked to, and appreciate staff letting me do that, is to kind of lend some level setting and perspective from the P&C side of things. We're a property and casualty trade association. So as to the Virginia law is a data privacy statute of general applicability that I think it's important to note includes a lot of exceptions. One of those exceptions that's most significant for our purposes is the Graham-Leach-Bliley Act exception, which for P&C insurers at least mostly takes them out of the act, recognizing that they have a parallel set of federal data privacy requirements that they comply with. So that's kind of just some initial level setting about what Virginia does and doesn't do in its act. I will say there are some aspects of the Virginia Act that we think are good in terms of data privacy laws. We tend to try to stay engaged on those anyway, even if they don't apply to the industry as it is, because an exemption can always be lifted, and you don't want to hang everything on just that. I can talk about some of those particular things in a little more detail if the committee would like to ask. The other thing that I want to make clear, just to connect this, and I think everyone remembers from the discussion yesterday, if you were present in the NAIC dialogue, there is currently proposed a very hot issue at NAIC around revising its model law on data privacy. There's a draft exposed on that right now. The comment deadline is April the 3rd. If it were April the 4th, I could tell you exactly what our comments were going to be. Spoiler alert, there are going to be a lot of them. We have a lot of concerns with the NAIC model, so the idea that there might be something for NCOIL to do here is not one that we are not open to, but I guess to be clear, we do have a parallel proposal there that very much does apply to the industry because that's what NAIC does. To that point, I would say that one of our sort of bedrock principles on any regulation here would be things that could be reflected by what the NAIC is doing. And what I mean by that is having one single set of standards. To go back to a point I made earlier today, not having duplicative requirements to the same thing that, which do you follow, how do you follow both, that sort of thing. And also having the enforcement of whatever is passed be in the hands of the state insurance regulator. We may or may not like parts of NAIC's proposal, but we do agree that however it's going to be enforced, they are the proper party to be enforcing it, and we think that's the right mechanism. And then finally, one of the other speakers alluded to the federal activity on this. There is some, more serious than there's been in a lot of years. Will that actually get anywhere in terms of amending Graham-Leach-Bliley or something like that? It's probably a slim hope given the state of federal affairs right now, but it's at least a possibility. And so we try to keep our eye on that as well because, again, we're trying to have one clear set of guidelines to comply with. I guess the final point I would make, and I think I can only speak to P&C, but I think this applies to a lot of insurers. As I said, the Virginia law is general applicability. People who are just in the business of selling data, that's literally all they do. Department stores, all kinds of entities across the spectrum commercially. Information, and I know this is not a new concept, but information is critical to what insurers do. I mean, at some level, the purpose of insurance is to help people understand risk and then help them protect against it. And we need good, and in some cases, private information from people to do that. That's part of providing the service, and whatever model might come out, we think that would be important to preserve. The final point I guess I would make, just to loop back, given what the Virginia law is and isn't, if NCOIL is determined to do something here, maybe it's not a model act, maybe it is some sort of a resolution that would support a certain set of exceptions to a law of general applicability. I don't know. I mean, I think we could very easily get comfortable with something like that because we have in other states. But that kind of sets the landscape as I understand it. Happy to answer questions whenever the time is for that. Thank you.
Thank you so much, John. Robert Harrell will be the next speaker.
Thank you very much. Good afternoon. Thanks, Chairman Bennett, for the invitation and NCOIL for asking me here. I'm Robert Harrell. I'm the executive director of the Consumer Federation of California and had worked for about half a dozen years for the California Department of Insurance as a deputy insurance commissioner, and prior to that had spent about 15 years as a staffer in the California legislature. So I think my role here in part is twofold. One, to try to give you a little bit of the local or regional flavor of California, one of the states that in Andrew's presentation was one of the first out of the box, if you will. I can go over that very briefly. I'm going to focus more on non-health, partly because I have less expertise in the health area, but I will touch on that. And then just kind of pivoting over to pick up on what John was saying from NAMIC about, big picture considerations as you decide to go down this road or not go down this road. So that's my role here. So let me jump in. I would also note I'm on the board of the Consumer Federation of America. Obviously, they have a significant interest in data privacy. Just per what John said at the federal level, the one thing I would just note for all of you to be aware of is for a state like California, Virginia, some other states that in certain areas have taken steps, important steps forward, the big concern that we always tend to have is if the feds act, is it going to override, is it going to be a floor or a ceiling? We prefer the floor so that states can go beyond that if they want to. I know that there's a lot of pushback historically from industry. They want a uniform standard. You hear it all the time, especially in the insurance area, the crazy patchwork quilt argument, I call it. I'm not unsympathetic to it, but I do think that as state legislators, you want to think about potentially in some areas going beyond. That will depend on local issues. Also, the NEIC, John mentioned what's brewing at the NEIC. I think that I think you called it hotly contested. I think that's perhaps an understatement. While I'm not in the middle of the day-to-day on that, I do think that's very important to the extent that NCOIL has significantly strengthened your relationship with NEIC. I saw evidence of that yesterday. I think this is an area where it's very important that you continue to coordinate and collaborate with them on that. I say this candidly as someone who has been historically a bit critical of NEIC because in California we would look at NEIC models in various areas and just feel like they were too weak in terms of consumer protection. And usually the argument in California has been how far above to go the NEIC model. But that's, again, part of what you deal with in your respective state legislatures. Some brief history. 20 years ago, I was fortunate enough to be the lead staffer on a bill that got signed by then Governor Gray Davis in California in 2003 on consumer financial privacy. I can tell you that was a multi-year battle. There was an initiative threat that forced folks to the table to negotiate in, I wouldn't say good faith, but in better faith, that resulted in that compromise legislation. That was SB 1, California SB 1 of 2003. Then State Senator Jackie Spear, who then went on to Congress and just retired from Congress after a number of years. California was the first state to do something on data breach, notification, and the like. The history in California has been that it's been initiative threats that have tended to force more meaningful conversations. That happened again in 2018, an initiative threat by a gentleman named Alastair McTaggart for stronger privacy laws led to, in California, there's a kind of a version of an indirect initiative where it didn't used to be the case, but now if something's about to qualify for the ballot, there's a sort of deadline given, and either the legislature will come up with an agreement such that the sponsors of the initiative agree to withdraw it or not, or you go forward and kind of fight the fight on the ballot. That was reached at the last minute in 2018. It led to Assembly Bill 375 of that year. Then, per John's point, there was what I call the rush to get whole industries carved out of that law, and insurance was, in fairness, part of that, for the reasons that John stated, Graham Leach Bly, other considerations. I will touch briefly on health. You may or may not remember when Governor Schwarzenegger was governor of California, there was a massive scandal, and it dealt with UCLA Medical Center. And essentially, long story short, what was happening was high-profile, particularly celebrity patients, personal private information was being leaked We now know, hindsight being 2020, that some of that was happening by staff at UCLA Medical Center who were interacting with so-called pay-to-play outlets like TMZ and others to get paid to leak information about a story. That spurred, I think, Governor Schwarzenegger to take action, and then there's been additional moves in health privacy beyond that at the state level that I won't go into the detail of for lack of time. So most recently in 2020, California supported an initiative, Prop 24, by about 55-56%, the California Privacy Rights Act. That is just now being implemented in California. A sort of privacy agency, if you will, with a minimum funding threshold was created. They've just been promulgating some rules. Those rules are at the office that officially makes sure that they're legal, et cetera. They should become final within the next month or two. So there's been a lot of action in California. I would urge you, whatever you do in this area, take a good look at the panoply of things that we've done in California. It is a state that has taken privacy rights very, very seriously and has been, I think, moving the ball forward. The all info is important. And I say this as someone who focuses less on health than on other areas, but I think one could make the argument that health info is almost first among equals. It is so personal. It is so private. It is so important. And we live in a world where portability of that information is actually important at some level for the future effectiveness of our healthcare system. That is no easy balancing act, but it is an important one as you consider it. Broadly, a couple of thoughts on if you go down this road. The Consumer Federation of California and many of our other consumer organizations generally believe that whenever possible, opt-in, making the individual consumer have that power to decide, is preferred to opt-out. What we know historically about opt-out regimes is at one level, they are you create an incentive with an opt-out regime to make a decision complex. And you essentially create an option where the more legalistic and confusing an opt-out decision is for the consumer, the less likely they are to exercise that. If you do as much opt-in as you can, where you can't do opt-in, do a clear, easy to effectuate opt-out. Again, our bias is opt-in, but if you go opt-out, we literally had readability experts take a look at some of these, this is a while ago, these opt-out notices, and they literally told us you had to be basically at a doctorate or PhD level to sufficiently understand the language in those opt-out notices. That does not serve consumers at all. You want to have something that's readable, understandable, and actionable. I'm mirroring my own comments from this morning. That is the goal, and it really cuts across a number of lines. I'm not going to go into too much detail about the Virginia model. I do think there are some very beneficial portions to it. I think you always want to be very careful about exemptions. That's almost always where the fight and the debate is. Whenever you want to go down the road of privacy at the state level, keep them as narrow as possible. There is always going to be that push-pull where various industries will come in and they will tell you an amazingly unique story that causes them to need a carve-out. Resist that temptation as much as is humanly possible. One other thing I'll just touch on as I wind down, two things actually. One is about definitions. They're very important, obviously. Sale. 20 years ago when I was working on this issue as a staffer, sale literally meant sale. The industry has changed and evolved, some would argue devolved, into you don't have the kind of direct sale that you may be used to 2 decades ago. It's all about kind of leasing, sharing that information. You can go online right now and essentially buy access to very specific populations of people, de-identified, that would trouble you and amaze you. That is a thing. So be very careful on your definitions about sale. Make sure you capture broadly all the ways in which value is exchanged, not just traditional sale or renting or leasing. Finally, a quick note on enforcement. John made the point about insurance commissioners enforcing. I want to make a broader point that goes beyond just the insurance area. Whenever you have enforcement, our view is you want whoever the regulator is to have enforcement capability. You should have your attorney general have enforcement capability. You should have, depending on what you call it, your county district attorneys have enforcement capability, parishes in some states or whatnot. In some states, you have large cities where city attorneys have a big enough shop where they might be able to enforce. And finally, there is, in some situations, a role for a private right of action. Now, you can put a box around that. You can limit the amount that could be collected or damages or things like that. But I think it's important to have as broad an array of enforcement possibilities as possible. I say that not because I want the privacy cops chasing after everything, but I do think that it makes sure that industries are as attentive as they need to be to following these reasonable rules and giving consumers as much control as is humanly possible over their information and what's done with it. With that, thank you very much, Chair Bennett.
Thank you so much for your comments, and thank you for everyone's comments. Do we have questions? I am curious, as a person who grew up sort of giving my data to the internet at an earlier age. I've looked around the world and seen what data privacy laws exist elsewhere, and in Europe it's pretty clear cut. The consumer owns their data, and this conversation's been very complex, but they seem to have figured it out, and I wonder what is the difference between Europe and the United States in this issue, and are they doing it wrong? I mean, do you see an avenue for us to do that? Do you even want that?
Yeah, I'll give you a real short answer, and then I'll expand just a tiny bit on it. In 2 words, the difference is political will. Now, there's a more nuanced version of that answer, Chair Bennett, which deals with historically, and those of you who've been in the insurance space have seen this. And I don't want to paint with too broad a brush, but I want to make the point that Europe, in a lot of areas, has tended to come out with fantastic rules in various industries and sectors. Then where things have gotten really challenging is in the enforcement of those rules. And again, I don't want to paint with too broad a brush. That's my sense of the challenge here. So I think it remains to be seen. I agree with you, Chair Bennett. They have laid down a very clear marker. Your information is yours. And I think that's the bias walking in that we ought to have to protect consumers. Then it gets trickier when you're dealing with enforcement. And you're also dealing with the EU, 20-something nations, right? And that can get a little funky too. So there are various multinational groups within Europe that are meant to handle some of this, but the marker is clear. The more that you can get that sort of clear statement of purpose, I think generally speaking, Chair Bennett, the easier it is to then flush that out. I hope that's responsive to your question.
I really appreciate that. My other thought, in Oklahoma, we've had this conversation. Just roughly off the top of my head, I can think of several more technology companies that are based in California than there are in the state of Oklahoma. And the thought is that a place like California, where these places are domiciled, has an easier time. Easier may not be the right word, but can more aggressively control or set standards. So I guess my question is a state-by-state solution the best from that standpoint, because different states have different levels of authority over these companies?
It's a fair question, and I'm more than a little sympathetic to the challenges that are entailed when you're dealing with different levels of standards in different states. I really am. It's one of the reasons why Europe has kind of gone down this road. Now, granted, those aren't states. Those are countries that, through the EU and the different mechanisms, have done that. Let me use an anecdote to kind of make that point. When we were in very intensive negotiations in 2001 and 2 and ultimately 2003 about the consumer financial privacy data law then, we were well aware that it was a California conversation that was very quickly going to turn into a de facto national standard conversation. Literally, right after the bill got signed by the governor, I think within a week or two, then State Senator Speer and I traveled to Washington, D.C., met with just now retired U.S. Senator Richard Shelby and others who had been part of that broader privacy coalition, because we knew that the opponents of the bill in California immediately raced to D.C. to try to take the legs out from under it. So in a perfect world, you have a national solution. But the concern that I have is historically that national solution has been too weak on consumer protection. So therefore, that's why we go into, Chair Bennett, the national solution is preferred, but having it be a minimum level of standard that states can go beyond if they wish. That's not perfect by any means, but I think it's the way that we try to protect consumers to the maximum extent possible.
Appreciate that. JP, welcome your thoughts on anybody else's as well.
Yeah, and I agree, in general you want a nationalized standard. Having said that, insurance is state regulated, and it's subject to specific state regulation. Your ability to sort of enforce it, I think you can take a look at the cybersecurity issue that the NEIC worked on, and the fact that they want to have control differently than the national standard. Also note that if you're looking at Europe, you're looking at a whole different world from a negotiation standpoint. There's I happen to have a boss who was the chief negotiator as the president of the NEIC in dealing with a lot of these issues and trying to figure out how to actually have American companies operate in Europe and have European companies operate in the U.S. And I'm not so sure that environment, the way they look at and I appreciate the idea and the consumer protection that's attaching to it, but I'm not so sure that sort of works in a place like the United States in the same way. And I'm not so sure people would be happy with the lack of access to certain types of products and the ability to sort of move data through in the same way that it works now. I mean, that would be a concern.
Sure, yes.
Yeah, just very briefly. First, I should thank Robert because he's done me the courtesy of, given my limited knowledge of this, bringing up relatively few of the topics where I know our position is the opposite of what his is. So,
you're welcome.
But I guess I think what this conversation has revealed, at least in part, this is a complicated issue, both in terms of who ought to be doing it and what ought to be done. And I guess I would say, for y'all's purposes, and obviously that's for y'all to define, the question probably ought to be, how does NCOIL fit into that? I would at least encourage maybe waiting in another month or so. You're going to know sort of what comes out of the NAIC. We can give you some more concrete feedback on that. And then again, if the idea is to do Virginia, it would be odd to have an NCOIL model that generally doesn't apply to insurance. So I think the concept of what the best way to approach this is it a resolution? Is it an actual model? Focusing in on what sliver of that belongs here might be the easiest path forward. Thank you.
Thank you. I really appreciate it. JB,
I would just agree and add on that you're looking at, to use Plato's analogy, it's the shadow on the cave wall that you're looking at here as you're moving forward. And we need to get closer to that Platonic ideal. We may not get there, but I think even having the conversation here, given that the NEIC is having it, given that it's happening in state legislatures, is going to be hugely important on a go-forward basis.
I've enjoyed the conversation too, and Will tells me that we have to stop it now. So I thank you all again for your comments, and I suspect we'll continue discussing this topic in some fashion. So if you have questions or feedback, please let Will or myself know. Next on our agenda is the discussion on the electronic delivery of insurance documents and potential amendments to the NCOIL Insurance E-Commerce Model Act. If you'll turn in your NCOIL hymnals to page 265, there are some examples of state laws dealing with this issue, along with the NCOIL Model Act I just mentioned. For this topic, we're going to hear from our speakers today and then determine whether or not to make any amendments to the model either at our summer or fall meeting. And we will start with Molly Zito. I hope that I pronounced the last name right. We're on a first-name basis, so much so that I don't know how to pronounce your last name.
Thanks so much, Chairman Bennett. I appreciate it. I'm really glad John left because sometimes as a Zito Italian, I like to chat with my hands. So sorry in advance, Jeff. Anyway, so thank you very much for having me today, and I appreciate being here. Molly Zito. I am the Deputy General Counsel for Regulatory Affairs for United Healthcare Central Region. And I appreciate the that this committee has talked about the electronic delivery of insurance documents at previous meetings. Thank you, Jeff, for teeing it up last year in Vegas. Really appreciate that. As part of United Healthcare's sustainability strategy, we are working to reduce paper usage not only in United Healthcare, but also in the healthcare system as a whole. And so what we would be interested in doing is working with members of NCOIL as well as stakeholders on an amendment to the NCOIL Insurance E-Commerce Model Act that would allow employers who have fully insured health plans to attest that their employees are wired, which means that they have access to smartphones or computers and internet, and that if they're part of the health benefit plan, that they would receive their health benefit plan documents electronically or through e-delivery. They would have the option of opting out and getting their documents through paper. And I want to emphasize that this would be an optional thing for employers. We wouldn't mandate it. And I also want to emphasize that this is in the group market. So just a little bit about the e-delivery landscape right now. We have state and federal laws that have been in place for a long time, much before employees had access to smartphones and computers and laptops that they carried with them. And so a lot of times that these laws hamper that. And so ERISA in 2002 actually did a safe harbor for plan sponsors or employers that allowed them to say that their employees were wired at work, which means that they had access to their health benefit plans electronically. And if they were wired at work, then the employer could send their documents electronically. This is different for fully insured plans. Fully insured plans are regulated at the state level, everybody knows that, and so we don't have that same opportunity on the state level. And so that's why we're looking for this amendment to give those employers the same option to say, okay, my employees are wired at work, and I can give them their health plan documents electronically. So there's many benefits to e-delivery. This slide outlines several of them. You know, there's ease of administration for employers. I'm sure a lot of you, I know my employer tells me if I want to see my paycheck, I need to go look on the internet. If I want my tax documents, I need to go look at the internet. If I want my W-2, I go to the internet. And so there's a lot of administrative ease for the employer if we do allow them to send the health benefit plan documents electronically, but there's also the consumer experience. And I really wanted to focus there for a minute because as we're seeing that if you have access to your health benefit plans ready on your phone or your computer, you have the option to Control F. What are my benefits for colonoscopy? What are my benefits for prescription drugs? And this improves health literacy and also like engagement in their personal health. And we think that that's going to lead to better health outcomes. Last October, Morning Consult did a poll regarding this very issue, asking employees, would you care if your employer sent you your health plan documents electronically? There's several statements on this slide, but the last one is the most important, that 94% of the respondents said that a proposal to allow your employer to send you health plan documents electronically, that they would approve of that. In addition to the benefits that employers and employees see, we also have environmental benefits of e-delivery. And then lastly, this is, I think, the most important slide, is that this law has started to be implemented in a few states around the United States. Like Jeff talked about last year, it was implemented in Texas. It's also implemented in Georgia and Iowa. The law is sitting on the governor's desk in Mississippi, and it's passed the Tennessee Senate. And so we expect it to be introduced in several other states as well this session. And so United Healthcare hasn't put forth any language for the committee today as for an amendment, any legislative language, but Will did include in your packets the Georgia law that was enacted, and we have drafted some legislative language along those lines, and we've sent it around to several health insurers and other associations that work with NCOIL. And so truly it is our hope today that we can work with you and our stakeholders on this between this meeting and our summer meeting in Minneapolis this summer to come to some consensus on some legislative language that we could put forth as an amendment to the NCOIL's insurance e-commerce bill. So thank you very much for the opportunity. I'm happy to answer any questions.
Thank you, Molly. Next, we'll have Jeff Album with Delta Dental of California.
Thank you. Delta California actually is the Delta Dental plan of record in 15 states, with about half of all Americans who have dental insurance are in one of our plans across the country. I'm going to work really hard not to duplicate everything Molly said, because I agreed with everything Molly said, and she's already said it. But I can give a slightly different bent on it, that all of the issues around paper-based transactions are more acute for dental, even, than for medical. So obviously, this is just a visual of how things work today. An employer buys a health or dental plan. They send a note, either by email or paper, to every enrollee and says, hey, do you want to opt in to electronic communications? And that leads you to a website where you start an account, and all of your health documents will flow there. The problem is, in dental particularly, fewer than 1% of dental enrollees actually end up taking the opt-in to electronics, while many medical enrollees also skip their chance to opt in, although I promise you they have a much better track record than 1% in getting their members to do it. Because let's face facts, as much as my dental industry people, colleagues who are here don't want to hear it, dental is not the most important thing to most employees, and not even to all state legislators. But the fact remains, medical, of course, is fundamental. And, of course, in banking and transactions, everyone opts in, almost everyone opts in to banking, because that's your money. Use it every day. So where an industry is in your mind in terms of a priority very much has an impact on how readily you read your option to opt in or opt out. And that's why we in dental see a real opportunity here to take advantage of how culture has changed in the 3 years of the pandemic. We have watched this society move electronically, and I mean people of all economic sections have learned how to order food, do DoorDash, do everything electronically, because it was a need. And we haven't dropped those things just because we're not wearing masks anymore. People are more likely to opt into electronic communications with their banks and brokerages, like I said, because that's where their money is. So what's the solution? How do we increase the number of people who electronic opt in? Why don't we give employers a little bit of credit? As my colleague said, Molly, when they sign up for work in many industries, and certainly not all of them, in many industries, it is an electronic connection that they are signing up for. That's their job. They receive their instructions electronically. They receive their initiatives electronically. They receive their appraisals electronically. Heck, they receive their paychecks. Their banks get wired, and they receive that electronically. That is the direction where we are going in. Let group benefit managers attest to who has access and allow them to opt in. Like I said, not all businesses. A trucking company might not have the same electronic connection to truck drivers as they do to other white-collar executives who might work on other aspects of that particular business. So, no, we're not saying opt in all truck drivers to electronics. We're saying let the group benefit manager make an educated, very educated, and then let's give every employee the absolute simple, easy right. And in this manner, I totally agree with Robert's comments earlier, that the opt-out must be simple. It must be easy, not what a college education person has to be able to read, something that a junior high school person would understand. Make it easy for them to opt out, and make it a legal requirement that they receive that option to opt out. My colleagues already mentioned this. This is a trend legislatively. Kansas beginning in 2018, Louisiana in 2019, Wyoming in 2020, Georgia, Texas, and Mississippi all this year. Texas was last year. And the last 3 states that have done this have all followed the same sort of legislative language, implementing language, and conditions for allowing group opt-in to electronics. A group benefits manager has the right to do it, but they're not mandated. They must attest, they must confirm that the people they are opting in have electronic literacy and electronic means to receive those communications. Opt-out must be made available at all time, anytime. They can go back and forth. That's their business. And there are exceptions to the type of health and dental plans where this should be allowed. Medicaid, Medicare, individual health and dental, including public health exchange plans. These are all forms of health care and dental care where there isn't a group benefit manager able to attest to electronic connection. Even if they've signed up for a health plan over the internet, that doesn't convey complete comfort and computer literacy. And so we are saying, no, we're not talking about any of those plans in this proposal. So in summary, it's a change from the current enrollee opt-in to paperless to a optional default group level opt-in with enrollee opt-out. It's needed because most health and dental enrollees never bother to read the fine print, and the proposal does not include individuals for whom there can be no attestation as to whether they are connected or not. And she's already covered the advantages of e-delivery, all of those things. And here I show you the typical paper transactional cost of a dental plan enrollee in a given year. There's all the documents that we have to send them every single time date of service has occurred. Some of them are once a year, and EOC is once a year, and EOB is after every routine. And you're at $975. And I just let you know, we sell dental plans at $15 per person per month. So for $150 annual premium, $975 is 6%. So we could be lowering the cost of dental care. Probably for health care, not as dramatic in terms of cost. There's all the other really good arguments. For dental, there are twice as many people who don't have dental insurance as medical insurance. And 6% could be the difference between buying a plan or not. People who have a plan are more than twice as likely to get care as people who don't. So this last slide basically shows some language that gets it done. This mirrors language that was passed in all of those states where we have championed this particular initiative, and we are optimistic that you'll consider this here at NCOIL as a model act. I'm sure we would get more and more states to get the ball rolling on this.
Thank you so much, and I'm happy to get a chance to introduce Robert Harrell again and get your last name right this time. And we'll finish the topic with you, and if you can keep it as close to 5 minutes, I'd appreciate it.
Thank you, Chair Bennett. Appreciate it. Robert Harrell with the Consumer Federation of California. Very briefly, in terms of California context here, when I was at the Department of Insurance, I spent the better part of 2013 and 2014, perhaps going into 2015, negotiating with the various sectors of the insurance industry about this very issue. And those were long, tortured, painful negotiations, but we were not opposed to electronic delivery of things. We just wanted to make sure there were certain protections for consumers and guard posts, if you will. So that's the context. I'll be quite brief, Chair Bennett, because I know we're nearing the end of the session and of today's proceedings. I probably would have to turn in my consumer advocate card for life if I didn't point out the deep irony of when it is something that the insurance industry or segments within the insurance industry is interested in, they can magically make it work. When it's in the consumer's interest and force the consumer to take an action, then all of a sudden it's too costly and difficult. I mean, let's just be aware of that irony. Our point has always been consistent: give people the maximum amount of control. Having said that, what gives me a little bit of pause in this group benefit manager situation is, does that person really know the situation of all the employees that they're attesting for? I mean, let's think about vulnerable populations, right? That could be lower socioeconomic status, lower education. We're having a debate in this country about broadband access in rural communities where largely it doesn't exist. We've also had a major shift in population coming out of COVID where more people are kind of working in all kinds of places. Let's just not be in such a rush here. And I understand the business argument. I really do. The savings, et cetera. But let's not be in such a rush that we kind of forget some of those protections, okay? Cognitive impairment. How likely is an employee going to be to acknowledge and admit and then pass that information along that there may be an issue of cognitive impairment? So these are signposts that I think are important that we don't forget. Redundancy is important in some circumstances. I appreciate that some of that has been built into the approach here, but you want to be very careful because the argument is, well, pieces of mail get misplaced, or they have the old address or something like that. My personal email account is a Yahoo account. That's quickly becoming a dinosaur, where most email accounts are Gmail or others. There's been stuff that I was supposed to get in my email account that I didn't get. So one of the debates we had in 2013 and 2014 in California was, how do you verify? How do you certify that it was actually received? And while that technology has advanced some, I don't think it's there quite yet where you have that level of confidence that you absolutely could bank on it. So these are just some bigger picture thoughts that I think are very important to the extent that NCOIL is going to go down this road. I do understand. I mean, the irony is that we started this afternoon, and one of the panelists talked about this sort of preposterous proposal in Oregon where people might be able to get a dividend, my word, not theirs, about what it is. Well, here, Delta Dental, to their credit, has just said it saves us $9.75 per year. Should the consumer get a little part of that? If you want me to opt in, make your case. And maybe that case isn't part of a financial case. And maybe if you throw a few bucks my way or give me a reduction in my rate or something, maybe then I am more likely to opt in. That is the idea that then leads to those kinds of proposals in other states and municipalities. So with that, I'll kindly shut up. I'm happy to take any questions. But I appreciate the opportunity, Chair Bennett, to weigh in on these two issues and from the consumer perspective. Thanks a lot.
Thank you so much, and I appreciate how often you use the phrase Chair Bennett, because I, again, never hear that at home.
I'm sympathetic to your plight.
Are there any questions on the use? Any questions? All right. Thank you all so much. This is a great discussion, and Will tells me we'll likely be discussing this topic in some fashion going forward, so if you have any questions, please let us know. Last on our agenda is a discussion on developments in direct procurement of insurance. And we have Bill Bryan with us today. He's the Director of Providence Insurance Partners, and he's going to provide somewhat of a 101 on the direct procurement and discuss potential next steps for NCOIL on the issue. Bill, please go ahead.
Thank you. My fellow panelists pointed out we're near the end of the time. I've decided to amend my comments to just repeating the term Chair Bennett over and over again. Actually, I'm going to make it even briefer. I'm here to try to give you all money. Even better, right? Money to which you and your taxpayers are legally entitled and are, in many cases, not receiving because of a lack of understanding of the way that we place insurance works. So, without further ado, independent procurement. Here are the things we're going to cover really quickly. What is it? Why do we need it? Why should this body be supporting it? What can states do to support it? And then what can carriers, such as ours, do to make it work better? Independent procurement actually, first of all, goes by several names. You may also hear it referred to as direct procurement, self-procurement, foreign procurement. All those terms mean the same thing. So we like independence, it's America. Independent procurement is what we call it. The history goes back to the late 1890s. There were two Supreme Court cases then which established a constitutional right for individuals to obtain insurance outside of their jurisdiction. One of my kids rudely asked me if I was a party to either of those cases. I wasn't. But I am pretty familiar with them. There's been a number of developments since then, 120 years. The McCarran-Ferguson Act, 1945, specifically recognized procurement as a valid means and something that was not precluded by McCarran-Ferguson. There was an important case in the 1960s, Todd Shipyards, which again validated the use of procurement and established some rules around taxation between the states. And then there was the NRAA, which was passed in 2010, which again addressed this issue of how to address taxation where insurance crosses state lines. Current status is it remains a fairly little known thing. There are probably some people in this room who know a good amount about it, and there are some who may not know anything about it. I find that to be true even in groups of experienced insurance people. So it's again, of the three main methods of obtaining insurance, it is the least known and least used, and therefore sometimes one that creates confusion when it is used. Why do we need it? This may go really quickly through this because we're not here to talk about health policy. This, by the way, my company exclusively provides stop-loss and reinsurance coverage behind self-insured group health plans. So we're talking about all this today anyway in the context of stop-loss for group health. So again, quickly in policy, facts all of you know, we have some real gaps in our in health insurance coverage in this country. We have about 70 million lower-income Americans who are functionally uninsured because their deductibles and their out-of-pocket annual maximums are as much as 10 times their annual savings. It means that you essentially have catastrophic insurance only. There's also more than 20 million people completely uninsured. Those ranks are going to be added to considerably when we get Medicaid. I can never remember the name, whatever it is. It's about to happen over the next year. So we have some gaps, and there are people innovating around those problems and coming up with interesting solutions. We work with several companies that do. Some of those things include policies that have no deductibles or low deductibles, the use of reference-based pricing, which is a great tool for controlling costs, very unpopular with providers and therefore with insurance companies that have network relationships with providers. PBM transparency is a big cost-saving tool. Often is the case that these plans, these self-insured group plans, are designed in such a way that they just don't line up with stop-loss policies that are available from admitted carriers in various states. I expect that to change over time. The market has a way of adapting to support what's out there, and we adapt as well, and including where we seek admission and whatnot. But generally speaking, it is very difficult to find on a timely basis for a lot of these companies stop-loss coverage that matches up with the innovations that people are putting in place to control costs in group health plans. Of course, there's no requirement under ERISA that you have any stop-loss at all. People could decide to be uninsured, which would be unwise, and in fact, we don't work with companies that allow that. So everybody needs to find stop-loss. Small businesses have it the hardest for various reasons, some for state rules, some for carrier rules, who they will and won't cover and under what terms. And this puts them at a particular disadvantage when it comes to a tight labor market where they really can't compete. Every store that goes out of business, another Amazon truck shows up in front of my house. Why am I here asking for your help? These are really valuable products. Some of you may have encountered at some other NCOIL events or NAIC events. HBA, which is a company that we do a lot of work with, they've had tremendous success going out with these low deductible or no deductible plans. They're very popular with employers and employees. The bad joke I started out with about giving you all money, when procurement is used, this generates a lot of money in premium taxes. There is no method currently in procurement for the reporting and reliable collection of premium tax. So hundreds of millions of dollars a year are going untaxed. That's particularly true. There's a lot of companies. If you look around online, you'll see a lot of companies that are identifying themselves as quote unquote captives. I think of a captive as being something that is captive, is owned by by a company that is insuring itself. There's a lot of companies that call themselves that when in fact insure many companies through protected cells or what have you. And in very, very few cases are the premium taxes ever reported or paid by those companies. NRA, which I mentioned in 2010, called for the establishment of national compacts amongst the states. Unfortunately, although there were two very well-intentioned and strenuous efforts made to create those compacts, they failed. So there aren't any currently. It's the wild, wild west. We had an experience, so a year ago or so, we said, you know what, we're going to require our insureds to report and pay and demonstrate to us that they've paid their taxes. And it happened to be that this program was being piloted in a state. I'm not going to name the state for reasons you'll see in a second. We're going to require you to report and pay that. And they did. Everybody paid. And, you know, we thought maybe thank you notes would be coming. Instead, what came was a lot of confusion, calls, questions, investigations, and we to this day now those clients are continuing to be pestered. I heard a story last week. A guy, an investigator, called up one of these people who paid their premium tax and wanted to ask him a bunch of questions about, you know, how he'd found out about the insurance company and how it worked and all that. And he said, listen, first, I don't know, I don't remember. Secondly, this is the best insurance that I've had in my company in 30 years. And three, I got better things to do, and hung up the phone. So we found that the lack of understanding is an unhelpful situation. Finally, typically we've seen when you have this sort of situation where you have a unclarity and a need for some sort of standardization that's not coming, the feds arrive shortly thereafter. So we think that is a definite possibility in this area, and one that we would assume that NCOIL as well as the NAIC would disfavor. What can we do? We would very much like to see, and I've discussed some with leadership here at NCOIL, the possibility of model acts and whatnot. We haven't come forth with one because the truth is more than 40 states already have legislation about direct procurement, about how it's supposed to work and what the taxes and all that. So we're a little unsure as to what a model act would actually say when all these laws already exist. However, there certainly could be guidance established to say, here is a standardized procedure for the reporting and remittance of tax, and we would very much like to see that. We also think there's value to establishing online directories by state where even for foreign or out-of-state insurers where information can be posted, key financial information, warnings by people who've had bad experiences and things like that. So we think there's a lot that states could do, but the biggest thing is really standardizing this reporting process. I can tell you that our company, and I'm sure many others, would really welcome the opportunity if we had a clarity as to how this was going to work, to demand that insureds give us the authority to report premium taxes due to the states and, in fact, pay them on their behalf, and it would result in a much cleaner system and a lot more taxes collected. Finally, what can we do? As I just mentioned, we can demand that authority to report the taxes, perhaps pay them. We already do encourage and facilitate timely reporting and payment of taxes. Educate and listen. I've spent the last 8 months flying around the country, talking to many of you and others about this issue to try to. It's pretty esoteric, and frankly, I've made a lot of eyes glaze over, but I keep going. And finally, we really welcome input as to any thoughts anyone might have as to a better way to skin this cat in terms of just, again, providing clarity and better method. And if you have any of those, that's what you do with it. Just email me, call me, talk to me, or ask me now.
Thank you so much, Bill. And actually, I'm going to, we do have to move forward just because we are a little bit over time. We started a little late, and I'm hoping to get us out of here by 3:10. So if you have any questions for Bill, please find him after this. And the one other thing that we have on the it wasn't on the agenda, but adding it here is our last meeting in New Orleans. We heard from Eric Harr of the Federal Home Loan Bank of Dallas, and he gave a presentation on the Federal Home Loan Bank system. and a couple of insurance-specific issues within that system. And Eric is here today, and I think you have 2 minutes worth of words for us.
Yes, thank you, Mr. Chairman. Years ago, I found myself on an elevator in Washington, D.C. with a member of Congress, and I had 30 seconds to sell him on a piece of legislation and get him as a co-sponsor. I wasn't successful, but I did learn an important lesson that day about condensing my remarks, so I will be under 2 minutes to wrap us up. I'm Eric Harr with the Federal Home Loan Bank System. Glad to be back with you. I was with you and this committee in November to talk about Federal Home Loan Bank lending to insurance companies. The FHL Bank System is a government-sponsored enterprise, a GSE created by Congress back in the 1930s. We lend money to insurance companies. We also lend money to banks and credit unions, but when we lend money to an insurance company, they will typically use the dollars they borrow from their regional Federal Home Loan Bank to buy mortgage-backed securities or treasuries for the benefit of the organization. They can also borrow money from us to pay shareholder claims, policyholder claims. The issue that we encounter, and this is potential model legislation for later this year, is this. When an FHL bank lends $1 to an insurance company, we take a little more than $1 in collateral from them as a backstop to what we lend to them. If an insurer gets into financial trouble or goes into receivership, a receiver can place a hold or a stay on all the assets of that failed or failing insurance company, thus prohibiting a Federal Home Loan Bank from accessing its collateral. That creates delays, it creates legal problems, and we are forced to charge insurance companies less favorable lending rates when we lend to them in states where we don't have a fix. So in 23 states, the Federal Home Loan Banks have worked to pass legislation successfully, making it clear that a Federal Home Loan Bank shall not be delayed from accessing the collateral and only the collateral that it is due. And we work in partnership with insurance commissioners and the receiver and the insurance company so that we have a positive resolution for everyone involved. And so we will be approaching this committee, Mr. Chairman, later this year again with this issue.
My notes indicate that that is true because Will wrote here, I think it's likely we'll continue discussing this topic in some fashion.
Thank you.
Thank you so much for your input here today. The last thing before adjournment is that Tom thought it would be nice of me, and it's true, I wouldn't be a public servant if I didn't remind you that we're springing forward tonight. Just the worst thing in the world, but just don't forget to do that. And if there are no other issues before the committee, I would entertain a motion to adjourn. So moved. Second? All in favor? Aye. All opposed? So done.
It's a hell of a debut by the chairman in his inaugural performance, I think.